Hi, I'm Mike Lee, author of Our Lost Constitution. I'm joining you this evening for another Facebook Live post in which we're going to be discussing the Establishment Clause of the U.S. Constitution. And in particular, we're going to answer a question that sometimes arises that people ask from time to time with good reason. The question is, why is it that the federal courts seem to get involved every time someone wants to discuss religion in public, every time someone wants to utter a prayer in public? Why is it that the federal courts get involved in things like school prayer or whether or not a particular city or town can have a creche or a menorah, a nativity scene in front of City Hall? Why does all this have to become a federal lawsuit? Why is that somehow a constitutional issue? This evening I'm going to tell you why, and I'm going to explain how a former member of the Ku Klux Klan got himself put on the United States Supreme Court, and after getting himself put on the Supreme Court, decided that he couldn't handle religious freedom. He wasn't willing to tolerate the influence of the Catholic Church in the public schools, and in part for that reason, was motivated to distort a provision of the U.S. Constitution. I'd like to begin by talking about the source of the part of the Constitution that is cited as the source for these decisions injecting the federal court system into whether or not we can have a prayer in a public school or at a high school graduation or a nativity scene at City Hall and so forth. The provision of the Constitution is called the Establishment Clause. It's one of two clauses within the First Amendment that deals with the freedom of religion. The first of those clauses is called the Free Exercise Clause, which says that the Congress shall make no law restricting the free exercise of religion. That provision provides an individual right. It's an individual protection. It's saying the government may not do something to you as an individual. The other religion clause in the First Amendment is called the Establishment Clause. And it says that Congress shall make no law respecting the establishment of religion, respecting an establishment of religion. In other words, that Congress may not declare a national religion. Congress may not sponsor any particular church or coerce religious practice or exercise. It's important to understand the historical context against which this was, in which this was adopted. When the Bill of Rights were written in 1791, at that time there were a total of 6 states that had established religions. Those states decided that they wanted to have their own official state church. And so the Establishment Clause was put in place for the specific purpose of making sure that here as elsewhere, the federal government didn't step too far. Some of the states, particularly those states with established churches, didn't want Congress stepping in and saying we're going to establish a national church, understanding that where Congress acts in light of the Supremacy Clause of the Constitution, federal laws trump inconsistent state laws that provide something other than what the corresponding federal law says. For that reason, some states were concerned that this might be a possibility, and that's why the Founding Fathers, that's why those who drafted and who proposed and then who voted to ratify the Establishment Clause wanted to make clear that Congress couldn't do this. They didn't want Congress stepping into this territory. So again, there were 6 states at the time the Establishment Clause was drafted and proposed and ratified that had established religions. No one understood at the time that this conferred any kind of individual right, because this wasn't an individual right. This was saying that it would continue to be the prerogative of the states whether or not to have an established religion. Now, I want to make very clear at the outset, I'm not in favor of state churches. I'm not in favor of states being able to establish a particular religion. I don't believe there is a single state in the Union today that would have an established religion. In fact, it hasn't been since, I believe, 1833 that any state has had an established religion. Nonetheless, states ought not be subject to getting hauled into federal court every time someone chooses to say a prayer in a public space, or every time a city decides to display a nativity scene or a menorah or something like that. Things like school prayer, whether or not students can be allowed to say their own prayer or be offered a moment of silence in which they can pray or alternatively meditate or something like that, those really ought to be decided at a state and local level. Each school district ought to be able to decide for itself whether or not to allow something like that. But instead, we have the system in which federal courts micromanage this process. Federal courts dictate to everyone else what they may and may not allow. And it ends up significantly restricting religious speech in the public square. Nearly every state, perhaps every state, I know my own state, has a state constitutional ban on the establishment of religion. I wouldn't want to live in a state that had an established church. But again, this isn't the point. The point is we want to keep the federal courts out of things that are not properly the business of the federal courts. So how did this all change? Why did it change? Well, the Ku Klux Klan, to make a long story short, didn't like the idea of the Catholic Church becoming more popular in America. And there came a time in the late 1800s when the Ku Klux Klan became very concerned about the rise of Catholicism in America. There was a revitalization of the Ku Klux Klan after it had dwindled a bit in the late 1800s, and about 1915 when the Klan started getting more powerful. The Ku Klux Klan proposed a number of laws within states that would prohibit any and all state funding for any type of religious instruction, in large measure because they didn't like the Catholic Church. They were decidedly anti-Catholic, and in addition to being anti so many other things, they were very aggressively anti-Catholic. So they tried to push these measures through various states prohibiting any type of state funding for any type of religious education, primarily because of this strong anti-Catholic bias. They pushed a federal law to that effect called the Blaine Amendment in the late 1800s. That one failed. When that one failed, that's when they pushed their efforts to the states. There was a man named Hugo Black who was a lawyer who ended up getting himself put on the United States Supreme Court after first serving in the United States Senate. But before he was elected to the Senate and before he was put on the Supreme Court of the United States, he was a Klansman. He took an oath to uphold and promote and protect and defend the principles of the Ku Klux Klan, including this anti-Catholic message that the Klan embraced, and including a message that would do everything, that the members of the Klan would do everything in their power to eliminate religious influence of any kind from the schools. And so, having taken oath to the Ku Klux Klan, Hugo Black, after he was elected to the United States Senate, about 11 years after he was elected to the United States Senate, got put onto the Supreme Court of the United States. This was in 1937. He was appointed by President Franklin D. Roosevelt. It was only after he was confirmed to the U.S. Supreme Court that investigative reporters looked into it and confirmed that he had, in fact, been a member of the Ku Klux Klan. Well, after he had been on the Supreme Court of the United States for about 10 years, a case came before the United States Supreme Court. The United States Supreme Court. The name of the case was Everson versus Board of Education. This case involved a challenge to the constitutionality of a New Jersey state statute, one that allowed school boards to reimburse parents for the cost of their children's transportation to school. Now, this included transportation to public school and also included transportation to parochial schools. The problem that Hugo Black faced was that Hugo Black on the Supreme Court was strongly against this sort of thing. But the problem he faced was that at conference, meaning when the 9 justices meet following an oral argument before the Supreme Court, after they've read the briefs, after they've heard the oral arguments of the lawyers in front of the court, the 9 justices will meet and they will announce only to each other, there's no staff present, just the 9 justices, how they're intending to vote. Now, 6 of Justice Black's colleagues voted at this conference to find the statute constitutional, saying, look, this is not a violation of the Establishment Clause. Whatever it is, it's not a violation of the Establishment Clause. It may or may not be a good idea for New Jersey or any other state to decide that it wants to allow school boards to reimburse parents for the cost of children's transportation to and from school, whether it's a public school or a parochial school. Hugo Black didn't like this outcome, but he came up with a devious plan. He decided that what he would do is switch what his vote would otherwise be and vote with the majority of the justices. You see, he knew that by doing this, there was a chance he would get assigned to write the opinion. Where the Chief Justice is in the majority, the Chief Justice designates who's going to write the opinion, who's in the majority. And when the Chief Justice is not in the majority, it's the senior-most justice who is in the majority. Sure enough, Hugo Black, as a member of the majority, ended up getting assigned the task of writing the majority opinion. Here's the interesting thing. So in that case, he bit the bullet. He decided to uphold the New Jersey state statute in this case, as he had to in order to be in the majority. But he sowed the seeds, he planted the seeds to make this kind of thing unconstitutional in the future. He sort of threaded this needle, and he planted these seeds in there to basically say that in the future you wouldn't be able to do this. He wrote a very tight, narrow opinion, one that basically made clear that anything else, anything other than funding for this type of transportation would somehow violate the Establishment Clause. And this was really tricky. The Justice Black reasoned in his opinion that the Establishment Clause had been made applicable to the states by the 14th Amendment. This is known as the Incorporation Doctrine. It's something you should know about the Incorporation Doctrine. It's a understanding by which the 14th Amendment's provisions are said to have incorporated or applied as against the states the provisions of the Bill of Rights. Not all of them, of course, would be deemed applicable against the states, because not all of them even involve individual rights. For example, the 10th Amendment is not an individual right. The 10th Amendment is a limitation on federal power. So too with the Establishment Clause. The Establishment Clause was also a limitation on federal power. So it wouldn't make any sense to make applicable to the states a protection that is there to protect state authority in the first place, to limit state power and not to grant an individual right. So Hugo Black rather deviously drafted this opinion that said that the Establishment Clause basically was there not just to prohibit Congress from forming an official federal government religion, but that it was also there to prohibit a whole bunch of other things. And this is why we end up with this Establishment Clause interpretation that doesn't really make any sense, and that in fact goes directly against what the drafters of the Establishment Clause could have intended by it, and what all those who voted to propose it and to ratify it could have possibly meant. But according to Hugo Black, this former member of the Ku Klux Klan, he basically rewrote history. Although he didn't offer a single citation in support of his description of the so-called feelings of the Founding Fathers, these feelings of abhorrence against any type of involvement between religion and government. He nonetheless stated this as though it were somehow conclusive fact. And so after he had explained that the Establishment Clause was incorporated as against the states, he then went on to explain that the Establishment Clause was somehow intended to, quote, erect a wall of separation between church and state. And according to Justice Hugo Black, that wall must be kept high and impregnable. We could not approve the slightest breach. Now, it's interesting. This phrase, this wall of separation phrase, is not found in the First Amendment. It is not found in the Establishment Clause. It is not found anywhere in the Constitution. Instead, this was a phrase that was coined in an obscure letter written by Thomas Jefferson to a group of Connecticut Baptists, which was rediscovered by Justice Hugo Black. And the problems with Black's use of Jefferson's metaphor are several-fold. First, constitutional provisions require the support of 2/3 of each House of Congress and 3/4 of the states. They cannot be created by a single person writing a single letter, even one as revered and as justifiably esteemed as Thomas Jefferson. And they cannot be incorporated into the Constitution, even though they were written by someone like Jefferson, who in a single line, taken from 60 volumes of writings, used this metaphor that was never proposed, never debated, never voted on by representatives of the American people. Second, although Justice Hugo Black claimed that Jefferson had played a, quote, leading, close quote, role in the drafting and adoption of the First Amendment, Thomas Jefferson was actually in France and not in Congress or even in the United States at the time. Third, Jefferson himself did not govern as if he believed that there was this a wall of separation between church and state. He believed no nation has ever existed or can be governed without religion, and nor could it be. He in fact used federal funds to pay the salaries of Catholic priests ministering to American Indians, and he also issued proclamations, Thanksgiving proclamations, when he was governor of Virginia. Jefferson did, of course, believe that it was sort of a king thing to do for a national head of state to issue religious proclamations. He didn't want to be to come across like a monarch, and so he told his attorney general when he was president that the purpose of his reference to the wall of separation in his letter to the Baptists was to explain to them why he did not proclaim fastings and Thanksgiving as his predecessors had as president of the United States. Fourth and finally, none of Jefferson's contemporaries, none of his predecessors and none of his immediate successors, governed as if there were prohibition against all kinds of state involvement in a religion, as if the federal establishment of religion prohibition required this sort of wall of separation. President George Washington, President John Adams, President Thomas Jefferson, and President James Madison prayed in their inaugural addresses. They actually prayed in them. It's not just that they opened with prayer, they themselves prayed. Presidents Washington and Adams and Madison called the nation to fasting and prayer with religious proclamations. And in fact, George Washington signed into law a law to provide support for religious schools in the Northwest Territory. There are all kinds of examples of how our early presidents, notwithstanding the existence of the Establishment Clause and the First Amendment, understood that this didn't require a wall of separation. This was put in there by Hugo Black. It was put in there in this 1947 decision called Everson versus Board of Education. It was put in there, I believe, because Hugo Black himself was a racist bigot. He was a former member of the Ku Klux Klan, and as such, he had sworn to fight against the Catholic Church. And he was really bothered by the fact that the Catholic Church had lots of influence through its parochial school system. This is why we have all these ridiculous lawsuits. This is why a federal court a few years ago declared it unconstitutional for the state of Utah to put crosses up at the sites of fallen state troopers. This, by the way, notwithstanding the fact that the state's majority of religion, members of the Church of Jesus Christ of Latter-day Saints, Mormons, the church to which I belong, doesn't even use the cross as part of its religious worship. And yet this federal court said that, oh no, you can't put up a cross just almost universally recognized as something that can be used as a symbol, as a marking place for a person who is deceased. And this is why we have all this federal court litigation over things as purely local and as non-federal as whether or not you can open a public meeting with prayer, whether or not a city hall can have a nativity scene or a menorah or something like that. So when you hear the word wall of separation used, when people speak as though this were somehow a foregone conclusion, that there can't be any kind of public expression of religious belief in any kind of public meeting, I'd encourage you to push back against it. Just because a federal court says that this is part of the Constitution doesn't make it so. It may be the case that you're going to prompt some federal court litigation if you have any type of expression of a religious thought in a public place. But it should not be this way, and we as citizens ought to push back against the idea for the simple reason that it's silly. And it's an affront to the Constitution. It's an offense to our own history to suggest that this is the inexorable command of the Establishment Clause, when in fact it was not, and when in fact this was put in there by a Supreme Court justice who was himself a member of the Ku Klux Klan. And he did it, I believe, for reasons that had everything to do with his bigoted hatred of the Catholic Church. I want to make one thing very clear. Once again, I mentioned this earlier, but I have no interest in living in any state that would have an established religion. I think it's silly. I think today we know better. It's not a good idea to commingle this authority, especially in a way that culminates in the official state sanctioning and recognition of an official state church. This would be a bad idea, and it would be prohibited by state laws and state constitutions in basically every state today. And again, it hasn't been since 1833 that any state has chosen to establish a religion anyway. This is not why we discuss this. The reason why it's important to discuss it is that it is absolutely silly, and it is the product of a racist, bigoted Supreme Court justice, that we even have to have this discussion, that we even have to have federal court litigation anytime someone is so bold as to express a religious thought in a public place. I discuss all of this in Chapter 4 of my book, Our Lost Constitution. I'd encourage all of you to check it out. Go check it out at a library or borrow it from a friend. If worse comes to worse, you can find it on Amazon in electronic format, as an ebook, as an audiobook. It's also available in hardcover and in paperback. If you like the book, please go to Amazon.com and write a book review. Let me know what you think about it. If you have the opportunity, please like this Facebook page. I'm trying to get more viewers to tune in so we can have an open forum, an open discussion about the Constitution, about ways that we can restore provision. Appreciate all of you for joining me, and thank each and every one of you for your participation. May God bless the United States of America.